Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday night. It's bright outside. It's very, very light outside. Well, we got some good court cases to go through today. So, it's been a while since we streamed together, huh? Feels like forever. Let's get to it.
I'm also ready to recall the Edward Sinclair matters 21 and 22 on the docket.
All right. Let me recall the Edward Sinclair matters, 23 CR 1001, 23 CR 962. Entry of appearances, please.
Good morning again, Your Honor. Lauren Ribel and Sergio Renteria for the people.
Thank you.
And Emily Valdez on behalf of Mr. Edward Sinclair, who is present on bond at my side.
All right. Good morning again to all of you. The court did receive the results of the UA, and Mr. Edward Sinclair tested positive for THC. We're here on complaints for revocation of probation. There is a request from the probation department that the court issue a warrant for Mr. Edward Sinclair's arrest. Any additional record from the people?
Thank you, Your Honor. Your Honor, in looking at the complaint that was filed, I think what's most concerning to the people.
Speaking of failing THC tests, Martha, 8 months on Prime. Thank you so much.
Is the new law violation, which is assaultive in nature, as well as the fact that the defendant is still not enrolled in treatment. I understand that there was or may still be a financial hold, but that's really the recent issue with treatment. But as the court can see, there's additional information contained within that complaint that the defendant has been non-compliant. And so, Your Honor, at this point, I am asking that the court act on that request for a warrant. I think that the probation officer suggests a $10,000 bond. And so I would just ask that the court impose the suggested bond amount. I don't have anything additional unless the court had any questions.
Thank you. Ms. Valdez.
Thank you, Your Honor. I am asking the court not to issue a warrant for Mr. Edward Sinclair's arrest based upon the second filing on that complaint to revoke probation. I do want to note that I think that the majority of those are the additions on there are all financial, really based. Mr. Edward Sinclair works in construction, and due to some of the weather and what is going on, his hours have been slowed down. And so he doesn't have the full paychecks that he has normally had. He also...
Yes, because probation requires just money. That's not the only reason, ma'am. Try harder. Josh, you should go up front and give the pilot some helpful suggestions on how to fly. They appreciate when you try to get into the cockpit to give them that information. Good luck.
So, and while have asked him not to make any statements about the new law violation, I do want the court to know he was given a summons in that case. And so he wasn't taken into custody. He also was hospitalized for the night. I do think there's some issues in that case that are very mitigating. He showed me a picture of what his face looked like. He was very severely injured. He had stitches in his lip. His eye was swollen. It almost looked like a baseball, on his face. But because of the appearance of those injuries, his work wanted him to heal before returning back to construction work. And so that also...
Oh, come on. They don't care if you have a cut lip on a construction site. They don't care. They're all beat up. They're in construction. Give him a map. So, is it just me, or is this court camera crooked? Because I feel like I'm going to fall out of my chair watching this court.
So backfired on him in terms of getting some more hours and having his paychecks reduced. He has not been able to get caught up. It shows that one of the places where he was enrolled in treatment, and he had attended some classes, but he was behind on payments. And so that is why he is not able to attend. They won't let him attend the meetings with a balance that's due and owing, and he has not been in a place where he could catch up on that. He has been in contact with his probation officer. He knew he had a UA to take today. He knew he was going to be positive for
Okay, because he's going to be positive on his UA today, the judge nails him. You'll see.
THC, but
epic.
was nonetheless definitely wanting to go and to demonstrate that he is not trying to hide anything, or there's not any additional underlying issues regarding other types of substances. He is working on getting his medical marijuana card. However, we recognize he doesn't have that and it's not authorized today nonetheless. But that he is trying his best. I also just want the court to know that last year that he was a victim of a shooting. He was shot twice in the neck and was hospitalized for months. And he has never really recovered from that financial hardship. And that has been a huge barrier for him. That case is ongoing where he is the victim. It's out of Denver County. It is one of the, it sounds like there was co-defendants. One of them is headed to trial. So he is participating in that prosecution. But he has had a lot going on. I also just want the court to be aware that the new case, that it is his stepfather that was involved with. Just so the court is aware. But I do think it's significant to note that they didn't take him into custody on that case, and recognizing that that appears to be of a significant concern from the people, understandably so. But that I do think there's some mitigating circumstances there, and the fact he didn't have to post a bond here and then requesting the $10,000 bond here based upon that, to me is somewhat disproportionate, but I realize these are felonies that he is on probation for too. He is asking this court to give him this opportunity. He is trying his hardest to get himself back into compliance, but it's the financial barrier that is the biggest hardship for him. But he wants to continue working really hard and to get his life in order. He is not opposed to doing the treatment. He knows it's important. It's just the circumstances I've laid out.
Well, Mr. Edward Sinclair, I have amended a second amended complaint for revocation of probation. You continue to not be compliant with probation. I understand finances can be a barrier, but you're using marijuana during this time period, which is not free.
She got you there, buddy. You say you don't have money to comply, but you're getting high. And I know growing up, we were told we were going to get offered all kinds of free drugs. Just say no, they told us. Because we were going to get offered free drugs all over the place. But lived my life, very rarely do I get offered free drugs. And when they are free, they come at a cost. Maybe not financially, but a cost. He's buying his drugs with money that he earned from his freaking construction job. Okay, he did get shot in the neck twice, and he was in the hospital for that. That is financially hard. However, he has a job, which means he probably got unemployment if he was off for any amount of time, which is money. So, she got you there, sir.
You need to prioritize your probation and supervision and being compliant with probation. So I'm going to issue the warrants in your cases, set bond in the amount of $10,000 cash or surety in both cases, order as conditions of that bond that you comply with all your conditions of probation. So Mr. Edward Sinclair, I am going to have you taken into custody based on the amended complaints. Ms. Valdez, how do you want to proceed?
Your Honor, if I may first ask the court to consider a lower amount on those bonds. He is, I mean, that will keep him in custody. He has no ability for all the reasons I've already laid.
Yeah, but think of all the money he's going to save now because he doesn't have to buy weed. So you can leave the bond alone.
Out to be able to
Welcome,
post
Dana.
that. If the court would consider something significantly lower, that perhaps he has some friends or other family that might be able to help support him to get him out. But with the 20,000 combined,
Thank you,
would keep him
Guitar
in
Slinger.
custody.
Thank you.
I
They called you
understand that, but
Gunslinger.
Mr. Edward Sinclair, you have not been compliant with probation. I'm getting amended and second amended complaints, so I'm not going to reduce your bond.
Your Honor, can we set this matter quickly?
I can set him to next week at 8:30.
If we can have that court date.
Does that work for May 29th at 8:30?
We'll make that work, Jonathan.
Right, let me call the De Herrera matter, 23 CR 1346, entry of appearances, please.
Good afternoon, Your Honor. David Bosner for the people.
Olivia Moran on behalf of Misty De Herrera.
Darn it. Looks like I forgot to put the speed back down on this part. Sorry, guys. It's going to be a little fast. Buckle up.
Who appears at the podium.
Also at counsel table, I have Ms. Lambert from probation.
All right, thank you. All right, good afternoon to all of you. We are set for sentencing today. I have had a chance to review the pre-sentence report. Let me check in first with the people. People prepared to proceed to sentencing?
Yes, Judge.
Any additions or corrections to the pre-sentence report?
Not from the people.
All right, and then defense ready to proceed to sentencing?
Yes, Your Honor, and no factual corrections.
All right, I did review the letter and the certificate that were filed as well. All right, let me go ahead and hear sentencing arguments from the people.
Your Honor, before I make my comments, would the court be to hear from Ms. Lambert?
Sure, Ms. Lambert?
Yes, Judge. Since our last court date,
I believe Miss Lambert is the probation officer. I believe. She doesn't actually say it.
I know that you gave her another opportunity to get into compliance and to get into treatment, detox, meet probation appointments. Unfortunately, this week I did file an amended complaint because she has not been compliant in those areas. Mainly with treatment as well. She has inconsistent attendance when it comes to her IOP program. UAs have been inconsistent as well. Her last UA in April was positive. I've been in communication with the treatment provider and with her other probation officer in Jeffco. Just last week, the officer in Jeffco said that she can help assist paying for UAs, but I told her that I can give access and that we'd have court this week. So I don't know what's going to happen with that case over there, but we just kind of left things like that. She's had multiple opportunities to reach out for assistance with me as well. One of our probation appointments after the last court date, she was also scheduled to do her PSI, and I think that was very long and hectic day for her, that when it came for us to do our appointment, I wanted to do a UA in the office and discuss those barriers and those things so she can be successful, but we didn't even make it into the office. I think that she has a lot going on, and then when it comes to taking accountability and owning up to the things that she needs to do, it becomes very difficult. I cannot conduct an office appointment with somebody who's not in that state to be ready to make those changes, and I rescheduled her, and our last meeting was supposed to be on May 1st, and she did not report on that day for our meeting. Since then, we've had very minimal communication, and I've been looking at her treatment attendance, and it's been sporadic. And then this week, the treatment provider emailed me and also mentioned that she encouraged Leticia to go into inpatient treatment, which she did not seem motivated to do. So I feel like there's just a lot of efforts that, she's had the opportunity to get into compliance with. And I don't know if there's any other specific details that you would like me to answer, Judge.
No, I don't. Thank you. All right, Mr. Bosner?
Your Honor, as far as sentencing goes, this court has been patient. This court has been merciful. This court has offered the defendant numerous chances, including on the last time. I don't know if there was another appearance in between March and today. But after that moment when the defendant was remanded for noncompliance, and then she posted bond again, and she was going to be at her liberty until the sentencing date, the court could not have been more clear when Your Honor told her directly that this is your chance, and I do not want to see more noncompliance. And we have a fifth amended complaint. In the amount of time I've been a deputy district attorney, I have not seen a fifth amended complaint. So what I'm left with arguing on behalf of the people is that she be sentenced to 3 years in the Department of Corrections on the F5. This case started as an F3, which obviously has a much higher punitive exposure. She entered into a plea agreement for a class 5 felony and was put on probation. It's been wildly unsuccessful. No other sentencing option the court has will meet the statutory factors for sentencing here. I pause because I don't want to have to argue that, but that is just where we were at. I wanted her to be successful on this last chance. The court wanted her to be successful on this last chance. Simply where we are at is she must be sentenced to the Department of Corrections. The PSI in its conclusion paragraph pretty accurately summarizes that she's been sentenced to probation 5 times and she's violated probation all 5 of those times. She's been sentenced to community corrections 2 times. That was provoked, and she received those tail sentences to the Department of Corrections in her history. Ultimately, what we're left with after this long road is a sentence to the Department of Corrections that is what is appropriate. It is what the defendant has earned. It's unfortunate. I was hoping to join in a different request with the defense on this case, but I'm unable to do so.
Thank you, Mr. Bosner. Maria?
Yes, Your Honor. First, I have a few letters that Misty De Herrera provided for me. I asked to approach, and
Yes.
I have shown those to the people.
All right, thank you. I did review the letters. Ms. Murray, do you want them back so you can upload them?
Yes, Your Honor, thank you.
Seeing arguments, Ms. Moran.
And Your Honor, before I speak, I'd ask, Ms. De Herrera has a few people here who would like to speak on her behalf. First is Kim Zavala, who also provided a letter that the court reviewed.
I'm going to kind of just wing this. I'm just a family friend of them, and I've seen Tisha's struggles with addiction, and she doesn't have family support, and her daughter have been homeless for well over a year. And I've seen her struggles on trying to get to probation. I've brought her to probation, and she's been blatantly ignored by her probation officer while waiting after court. I've given her several rides when I can. She doesn't have family support. I feel like she's turned over a new leaf in her life. She went to detox. She went willingly on her own. I mean, I don't know behind the scenes what that, was about. And she seems different to me. She seems different in the fact that she calls me and she's like, I went to class, and she's excited. And she says, there's people who actually care about me and people that want me to do well. They now have a home. Her and her daughter now have a home, which they haven't had for over a year. And her daughter's going into their senior year of high school, and she needs her mother. Whether or not, I don't know what your decision's going to be, but I believe in rebuilding a family. And this family is really, really trying right now. In the past 3-4 months, I feel like she's taken a turn, and she wants to rebuild her relationship with her daughter and build her family and be a mom, because she hasn't always been the best mom, and she'll admit that. But right now, I feel like she's really taken a turn that she's done with that life. She's done with being an addict. She's done with that life, and she wants to move forward in her life and provide a better life for her daughter, who, like I said, who is going into her senior year in high school and needs her mother and needs a home to be at.
Thank you.
Let's Your Honor to ask that Frank De Herrera be able to speak.
All right, Mr. De Herrera, come on up.
How you doing, Your Honor?
Mr. De Herrera.
I would just like to say, Tisha's been trying to help me, and I've got kidney disease, I've got diabetes, I've got dialysis 3 times a week, and she's really been trying to help me a lot. And she's actually been there for me for a caregiver, kind of is what I would like to say. I live in an assisted living facility, and they assist me a little bit, but she assists me probably more than they do. And if she goes away, then I won't have that assistance anymore. But and that's pretty much all I got to say. Is she does help a lot.
Thank you.
Yeah, okay, thank you.
All right, this
And-
next one is the hard one.
Finally, Your Honor, I'd ask Aviana, her daughter, be given a chance to speak.
Good afternoon. What would you like me to know?
I would just like you to know that I know my mom isn't the perfect person at all. Nobody in this world is perfect. She's owned up to her mistakes. She's admitted them to me. She's been nothing but truthful to me. She's built our relationship. There was a point in time I wanted nothing to do with her, and now I would do anything to stay in the home with her. And Kim was right. I do need her for my senior year. She's getting her stuff together. She's making sure I'm taken care of. And I don't want to see my mom go down a path that she shouldn't.
All right. Thank you so much for your statement. Ms. Maria.
Your Honor, ultimately, we're asking the court to sentence Misty Herrera to recovery court. Now, Misty Herrera,
See, now her lawyer should be choking up a little bit here, make it look better.
well, let me back up. The court got to read the pre-sentence investigation, and in that, it got to see and learn about Misty Herrera's struggles as a child, where she suffered from significant abuse and was ultimately, unfortunately, kicked out of the house, which forced her to drop out of high school. That unfortunately started and put Misty Herrera on the path that she's on today, leading to addiction.
You're right, guitar slinger. You're right. So most people definitely don't don't, go sober the first time they try to quit. It takes multiple times. However, but when you're on probation, most people don't get violated 5 times. That's a lot. Jen.
Which ultimately kicked off this vicious cycle of ultimately being in and out of the justice system, where, frankly, Your Honor, all of her cases are tied to addiction. Ultimately, in Misty Herrera's case, if you're able to treat the addiction, you treat the criminal behavior. If we don't treat the addiction, I hate to say it, but we're going to end up in the same spot where Misty Herrera is picking up new cases because of her addiction. Understanding that she has been on probation, and probation, obviously in this case, was unsuccessful. She's never been given the opportunity to participate in problem solving court before. She's been placed into community corrections. She's done probation. She's done DOC. None of those were ultimately successful in helping Misty Herrera address her addiction and be able to move forward with her life and to be able.
My mom was in court, in a courthouse, a couple months ago. She was not the one, she was not the defendant. My sister was, but her and her husband were running through the halls away from the guards. I wasn't there. I just heard the story that she had outbursts in the courtroom. And the judge kicked them out of the courtroom, and they went. And then the guards tried to get them, and they ran. They're old. They're both elderly. I think the guards just let them go because they're elderly. They're old. But yeah, the last thing they did in a courthouse was run away from the guards.
To put her addiction behind her. And I say that, Your Honor, because, ultimately, none of these programs are designed to treat addiction. DOC, ComCore, probation, they all certainly have resources and are able to help. But Recovery Court is unique in the fact that it has these national standards that are designed to treat addiction, where she's going to be receiving intensive structured supervision. She's going to be in court weekly to start off, and is going to get frequent court review and accountability. The treatment she's going to be receiving is going to be evidence-based substance abuse treatment, and importantly, she's also going to be receiving mental health services as well. All that to say, Misty Herrera needs Recovery Court. Frankly, I think the community is best served by Misty Herrera receiving Recovery Court, because Misty Herrera wants, and let me back up a bit, Your Honor. I understand there was a new complaint. I understand things haven't gone well on probation. As the court saw in my filing, she did detox. She was in there for 5 days. Since getting out of detox, she has been in IOP with creative treatment options. She's completed 20 sessions. And I understand it's far later than the court would have liked to have seen, and the court would have liked to see her do that a year ago. But frankly, Ms. De Herrera, I'll say it's better late than never. Ms. De Herrera is wanting to make those changes. She's showing that she can make those changes, and that addiction ultimately is not a linear path and is going to have bumps in the road. She now, though, has been sober for about a month since getting out of detox. I understand there was a positive test shortly thereafter, but that reflected pre-detox use. But since getting out of detox, she has been clean. Misty Herrera wants to participate in Recovery Court. She would benefit from it, and frankly, with the sentencing factors under 18-1-102.5 are best met by Misty Herrera participating in Recovery Court. Specifically, Part E is a sentence length and a level of supervision that addresses the offender's individual characteristics. Misty Herrera is an addict. Misty Herrera will benefit from addiction treatment. The best treatment she's going to get is going to be in recovery court. She's done 7 years DOC, and I understand it gets to a point where sometimes DOC is the only option court has left, but we haven't gotten to that point with Misty Herrera. She's willing and ready and able to participate successfully in recovery court. And she knows, and I'm sure ultimately she knows that if recovery court does not go well, that the court will be imposing a lengthy DOC sentence. But she asked for the opportunity to participate in recovery court, and where she will be able to ultimately address her addiction. And we do believe it will be successful and that the court will not be seeing Misty Herrera again. So for all those reasons, Your Honor, I ask the court impose a sentence of recovery court.
Thank you, Ms. Moran. Ms. De Herrera, is there anything you would like to say before I sentence you?
Yes. Read this one.
Here you.
Your Honor, thank you for allowing me to.
No. Just pause. We don't need this yet. Monica, thank you so much for the gifted memberships. I appreciate it. Hello, all new members. Hello. Jen, thank you so much. I love you. I miss you. All right. Here we go. Waterworks.
Opportunity to speak today.
Oh.
I sincerely
Thank you for the cheers on Twitch too. Thank you, Monica.
apologize for the delays in addressing this revocation. I'm ready to move forward and put this behind me as I focus on my sobriety and new opportunities and rebuilding my life. I have taken significant steps to overcome my addiction, and I am currently on methadone and have completed detox. Additionally, I am in the process of becoming my uncle's legal caregiver, which has provided me with a sense of purpose and responsibility. I've also undergone extensive training with Full Circle to be his caregiver. Since our last meeting, I have been actively participating in intense outpatient treatment, IOP 3 times a week, and I genuinely enjoy these classes. I am only 4 classes away from completing the program and earning my certificate. This commitment to recovery is a clear indication of my desire for change. Recently, when my attorney mentioned a recommendation for the Department of Corrections, I felt overwhelmed. However, instead of sabotaging and resorting back to old habits, I chose to attend my class and reach out to my peers, applying the coping skills and strategies I have learned. I am proud to share that I have secured stable housing, which alleviates the stress of wondering where I will sleep or whether I will have enough to eat. I no longer feel the need to resort to crime to survive. I am in a healthier mental, physical, and emotional state, and I am ready to face my consequences related to my revocation. I understand that I'm an addict and that I need help, and I genuinely want to change, and every day presents new challenges. I am asking the court to consider my progress and the support system I have built within the community. I believe that access to resources and coping skills in the community setting will be far more beneficial for my recovery than incarceration in the Department of Corrections, where I would not have the same access to support. Thank you for your consideration, and I appreciate the opportunity to share my journey with you.
Thank you, Ms. De Herrera. Well, Ms. De Herrera, I'm very familiar with your case. That's oftentimes not a good thing. I gave you a chance to be on bond and required you to be compliant with probation. And the reason I wanted to give you that opportunity, because I knew recovery court was on the table for you. And I wanted to see if you were really committed, because it's more than just your addiction. It isn't it. Your addiction is huge. Like, that means you've got to comply with orders. And that means maybe with a probation officer that you don't like, or maybe you don't like some of the things your probation officer wants you to do, but that's what would happen in recovery court. And I wanted to see if you would engage in that way. And then I get a fifth amended probation revocation complaint in which you're missing UAs, you're not 100% compliant.
Snoopy.
And frankly, Misty Herrera, that was your chance to show me that you meant it. That you meant that you could get yourself together and engage where you needed to engage. I read the letters and I see that you're starting to engage and that you're attending group sessions and that they're going to miss having you there if you were sent to the Department of Corrections. But at a certain point, Ms. De Herrera, you got to make that decision to engage, and I'm not seeing it.
I promise.
I'm not seeing it.
I promise, Your Honor, I won't let you, I will comply. I won't see you again unless it's completion of recovery court. I promise you, please.
I thought that would happen when I gave you a chance on bond.
But I've been compliant. I've been trying to do everything. Please, Your Honor.
Not. And Ms. De Herrera, your attorney's right. There's lots of, the statute requires and lays out the purposes of sentencing, which is rehabilitation, but also includes punishment and also includes community safety. I'm a firm believer in our specialty courts and recovery court, but someone needs to be ready to truly engage in probation.
I am.
You didn't in that little time that I gave you a chance on probation.
Please, Your Honor, please.
So Ms. De Herrera, I have to follow through with what I say, because if I don't, then my word means nothing. And also, you need to be held accountable for your actions and your lack of compliance with probation during this time period that I gave you that opportunity. So Ms. De Herrera, I am going to sentence you to 2 years in the Department of Corrections with 2 years of mandatory parole. Ms. De Herrera, I really hope from the bottom of my heart that you get yourself into a program or get in a state of mind that you can be in treatment and be compliant, but you're not there yet. You're just not. And as much as I want to send you to recovery court, I don't think it would be a place for you yet. You're just not there yet.
I promise I won't.
I heard that from you before.
No, I promise. Please, my uncle.
So
My uncle
I
needs
will-
me, my daughter. Please, please.
I will
Your
award
Honor.
7 days of pre-sentence confinement. But Ms. De Herrera, at a certain point, you have to be held accountable. You've gotten chances on probation. You've had opportunities in community corrections. And
Your Honor, my
there's no way.
daughter is going to be homeless.
I'm sorry, Ms. De Herrera. All right. Anything
Can
else
my
that we
daughter-
can
please, I
address?
Not from the people. Thank you, Judge.
No, Your Honor.
All right, thank you.
Can I at least give my daughter a hug and
She'll probably be there for what, a year? Maybe not even that long. This judge is really good. He really, really is so good.
Richard Bishlani for Mr. Villegas, who appears in person and in custody. If we could set this for a plea, he's not being held on this case. I've already talked to him about if he's getting out on his case upstairs this morning, he'll have to do an application at our office.
I want the DA to do two things. Mr. Walser, Mr. Bremer didn't hear this. This is based on the statement that was filed. The victim said wife has a broken wrist, had neck, back injuries, and substantial damages, like $129,000. So I am not sure what plea agreement I'm willing to accept. It is not, I'm going to require the DA to make VRA contact on this one before I accept an agreement. But it does seem that the defendant or his insurance company paid the costs.
Yes.
So I want the DA to verify that, which I don't understand. Where I'm confused is if insurance covered it and it was defendant's insurance, not the victim's insurance, there shouldn't be a deductible because they typically cover
I'm
the
not sure.
deductible.
I was just going off of the motion that was.
I know, that's why
Yeah.
I'm trying to make sure that Mr. Vegas
So why don't we give them a couple of weeks to do that? Is that okay with the court?
It is. Mr. Vegas, I will tell you though, if you get sentenced and you fail to appear on this case, based on the amount of losses, I may not accept a plea agreement that doesn't call for a very lengthy jail sentence. If someone is driving under suspension and causes an accident with major injuries, it's not an infraction. But I don't know, again, the nature,
Yeah.
It could be, ow, my back is sore versus, oh, my
Right.
back is broken, and I need to know the difference.
And I can tell the court, it looks like the offer would be to the MT1 careless causing with 48 UPS, 6 months court supervised probation.
And
With VRA, would the court accept that, or do we need a VRA completely different offer, in other words?
I don't know.
Okay,
Depends what the nature of the injuries were.
okay.
I'm not sure I'll accept 6 months because,
And supervised probation would be fine. He's going to, if it's concurrent to his case upstairs, if that's what's mentioned.
and I would accept something
Yeah.
along those.
Okay,
But based on the nature of the injuries, I said I didn't want to do this as a paper plea.
Yes, that's
That's
fine.
And I think Judge Veller is doing the same on serious bodily injury cases. Not regular injuries, but where it appears to be serious bodily injury.
Gallegos who appears in person and out of custody. Looks like this is a return on a summons.
It is.
Judge, I would just ask to set this maybe when the court's back. We could do like June. The court has availability June 10th or,
What are you asking me to set it for?
Judge, I would ask for a setting, but if the court wants to set it for a plea, I think that's also fine.
Counsel, I'm setting a revocation hearing is what I'm going to do. If it's resolved, I'll take it. But based on the allegations where she twice checked herself in and didn't show up and complete her treatment, including as recently as, so it said the allegation includes August 18th, she was returned to STIRT. She left against professional advice. On April 2nd, she was again referred to STIRT at her request and then did not show up for her bed date. So I am scheduling this for a revocation hearing because I've already in this case.
I call it, Your Honor.
Hey, ma'am, twice. You also left. I'm scheduling a revocation hearing. You're either doing treatment or you're going to be sitting in jail.
And Judge, what I can let the court know is she's coming into the office on Tuesday to meet with my social worker. I will say her Medicaid lapse, which is making everything really complicated. But if something changes and we do get her into inpatient treatment, I will obviously let the court know as soon as I can. But that's the plan.
Well, right now she also has a revocation in the DM1.
Yes, Judge.
And
They have to go treatment too, Judge. I kind of,
okay, Ms. Gallegos, addicts always come up with excuses.
and I want to go, I need it.
You need to hear this. I don't want you saying anything. Hear me loud and clear. Most addicts I have dealt with will always put off. Why do something today when I could put it off until tomorrow? In my courtroom, procrastination works against you.
I'm actually detoxing right now, Your Honor. I'm not getting, I'm not going to have methadone put on Medicaid.
Okay, Pam, you've had multiple cases. I will tell you, your options are likely going to be sit in custody in a county jail or go into a treatment facility. And if you make excuses, then you can sit in custody for a year. Most addicts put it off until they feel they have no other option. You either have to do it because you want to do it or you sit in custody. But if you're making excuses and finding ways not to do something, I will do it for you.
I'm actually detoxing, Your Honor.
I am looking at strategies for behavior change where they have been giving you warning and verbal reprimands about your behavior since April of last year. And I'm looking repeatedly, and I want you to hear this of why I'm saying this to you. It's not out of anger, but it's out of a wake-up call for you. April 28th, warning verbal reprimand. May 27th, warning verbal reprimand. I'm not going to go over each increase. July 7th, there was another sanction. August 18th, another sanction. October 14th, another sanction. November 18th, another sanction. December 18th. So I will tell you, and I'll stop now because there's about, 10 or 15 more.
Snoopy, I'm wondering how hard it is for you as a officer or an old officer to watch these court hearings, because I dated a cop once many years ago, and they were all so frustrated because they kept arresting these people, and then a week later the people were back on the street again, and then they would arrest them for selling drugs, and they were back on the street again, selling drugs, back on the street, over and over and over and over again. So, Snoopy, when you watch these court cases, doesn't it frustrate you? I would get frustrated. I am frustrated when I watch these a lot of the times.
I have a second view, which is if probation has already used all the tools in their toolbox in warning you, and now you're back in front of a judge on a revocation, why should I even consider probation anymore at all? If probation has already said, we've warned her, we've worked with her, we've warned her, we've worked with her. I am not the type that says, wait till dad gets home. I wish probation took a more proactive view and took you into custody. Because I bet you if they took you into custody as a modification of probation, you would have gone to your bed dates instead of having a revocation in this courtroom. Ma'am, this is a year of warnings. You are still in the excuse stage. The phrase they use is pre-contemplative. You did not have COVID for a year solid. You were in treatment and you left treatment. The more excuses you give me, the more likely I am to take you into custody. Stop with the excuses. So I am scheduling a revocation hearing. I am scheduling it far enough out where your attorney can try to get you into treatment. But I will tell you, if you violate between now and then and probation files an affidavit instead of a summons, I will sign a no bond warrant for your hold. And you will stay in custody until the hearing. So you're either compliant or you're in custody.
Can I just go to trial?
Okay, Mr. Geyer, I'm going to call you at the end of the docket. If you keep interrupting me, it'll be easy because I'll take you into custody for contempt and then I'll appoint a lawyer while you're in custody. Your case is called last. All right. Any additions or corrections to the alcohol bill?
Nothing, Judge.
Here's going to be the problem then. The plea agreement says it's a first. It says there's a prior conviction in 2009, which would make the plea illegal. Unless it was a successfully completed deferred sentence. I don't know if the DA has a record. But they do list a case number.
Is it the case number 17M1475?
No, that would be a
So
different
do you have a record
DUI.
that 17M1475 was a successful deferred?
No, 2009 case, 9M91.
9M90.
And he has a DUI pending right now in Otero County.
In case you're counting, that makes 4. He had one in 2025. He had one deferred. He has one pending in another county, and then he has this one. And they came with a plea deal as a first offender.
And I don't know if he pled guilty, but if he pled guilty, this would be a third.
Judge
In other
can't
words,
count the
it's
one
not
that
based
was.
on, if that sentence has already occurred in 2016-30, this would actually be a third offense, not a second.
Okay.
So, yeah, I
I'm
can't.
very good
let
at
me just-
paying rent. That I'm very good
So
at.
if that
And it
is,
does not matter based on the case law, which case occurred first in time. It's at the time of sentencing, whether there's a prior. There's a case 100% directly on point.
Interesting.
All 4 points. So you can't race to have, if someone has 2 active cases, you can't plead to the second and say it's a first, and then plead to the first and say it's a first. And I can give you the case site if necessary, but it is right on all 4s. That's the problem. And it involved a DUI, by the way. I will cite that for the record. Let me take a look at something.
I found out last night that my dog cannot walk for 1 hour and 44 minutes and would need to be carried because my tire blew out when I was on my way to pick up my son. So I thought, we'll just walk home. And it took 1 hour and 44 minutes to get home. And I had to carry my dog a lot of the way because she could not do it. That's because I let my dog lay around too much. That's my fault. I'm a bad dog parent. I need to get her out more, active.
It's 26T30. There was a plea to a driving impaired. So this is the minute order I'm going to make at this
I
point.
carried her.
And pull up the case.
Poor puppy. Psst. It's flat, Donald. Tow truck driver the next day was extremely handsome, though. It was all worth it.
I'm going to cite the case real quickly. It's a U.S. Supreme Court case, People versus Woodside. The defendant picked up 2 separate alcohol-related offenses he committed in relatively quick succession, and his sentence for the Weld County offenses, which had occurred first in time, included second offense penalties because he had already pled guilty to the later committed offense in Grant County. Defendant filed a petition to show cause, and the court said on an issue of first impression, a second offense penalties for DUI do not require that the conduct underlying second offenses predate the conduct underlying first offenses. 100% on all fours, and it was a unanimous Supreme Court ruling. So here's the minute order. Pursuant to People versus Woodside, WOODSIDE, the court finds that this is a third offense and the plea is therefore unlawful. I am setting aside the plea agreement as an unlawful agreement.
Okay, understood, Judge. If we could just reset this as soon as possible, I think as the court is well aware, Mr. Owen does have significant credit on this case.
I know.
I'm sure we can work something out. So if we could just reset this, I know the court is out, but if we could just reset this, we can work something
Well, the
out.
problem is it's a mandatory jail sentence. And it is mandatory 60. Now, I can give him credit for any time he's already done in the case.
Yeah.
But
And I do believe he's done 60 days on this case, Judge.
and I can give credit and I can even give, so let me just. I can put June 8th at 11.
That would be it. Okay.
That's why I wanted you to hear the case. It's directly on point and it gives the court very little discretion.
Thank you, Your Honor.
Yes.
He ran out of there so fast. He thought he was, well, they weren't going to handcuff him because he only had one arm, but he was going to go to jail. All right, let's look at a good bond fight.
Don't say anything. Are you there? Can you hear me? Shake your head if you can hear me.
Yes.
Okay, don't say anything, okay? Let me do the talking.
Okay.
Judge, my paralegal, Alex Brindavong, spoke with Ms. Schlechter today by phone from the Crowley County Jail. She was able to advise her of the affidavit involved in this case and Ms. Schlechter's Rule 5 rights. So at this time, I would waive any further formal advisement on her behalf.
All right. Thank you for doing so, counsel. Let me turn to you, Ms. Gonzalez. Considering bond in this case, there was a CPAT-R filed in this case that has a total score of 6, putting her in risk category 1. What would the people's recommendation to the court be concerning bond?
And Your Honor, I would note that Ms. Selecta is a multi-state offender. She does have convictions in Colorado for theft and ownership of a dangerous dog, and a conviction out of Texas for theft as well. There are 9 reported failures to appear, none of which are particularly recent. She also has a current pending VPO case, which is Crowley 26M23, which involves one of the listed victims in this case, and is also on a traffic deferred judgment and sentence in Otero case 26R43. So ultimately, despite a minimal history, the facts as alleged here are alarming, specifically as it relates to the number of individuals who were threatened with the firearm that was allegedly identified to be in the defendant's possession, and the fact that she reportedly shot at least one of the individuals who was threatened certainly demonstrates a willingness to follow through with those threats made. So for those reasons, I do believe that there is a danger to the community that is posed, at least by way of the allegations, and I would contend that bond is appropriately set. In addition, I would ask the court to issue full no contact orders involving the listed victims, and would also ask that she be ordered not to possess and relinquish any firearms during the pendency of this case. But with that, I have nothing further.
All right. Victims that I have are Micah Aronston and Fred Hunsaker. Is that right, counsel?
That is correct, Your Honor.
All right. Mr. Torres, let me hear from you then concerning bond.
Judge, I'm not sure Ms. Schlechter was on the line, so I'm going to recite the citation of authorities, both for her and for the benefit of the record. As the court is aware, in setting bond, first and foremost, I'd ask the court to take into account Ms. Schlechter's presumption of innocence. That's afforded to her under the 14th Amendment to the United States Constitution and the Colorado Constitution, Article 2, Section 25. It's also afforded to her statutorily by the Colorado legislature under Colorado Revised Statutes 18-1-402. Second of all, Judge, I'd ask the court to honor and recognize Ms. Schlechter's right to a reasonable and non-oppressive bail in this case. That's guaranteed to her from the prohibition against excessive bail and the right to be free from cruel and unusual punishment from bail under the 8th Amendment to the United States Constitution and Article 2, Section 19 and 21 of the Colorado Constitution. That is also codified under Colorado Revised Statutes 16-4-101. I'd also ask the court to take into account the legislative guidance that's been given to trial courts such as you setting bonds under CRS 16-4-103, which asks that the court not use bond as a way of pretrial detention, but instead to assure attendance, number one, and to prevent any new violations of law. Lastly, in accomplishing those two goals, Judge, you are required. It's not discretionary. You're required to, first of all, give a presumption in favor of release with the least restrictive non-monetary conditions. Number two, you're required to take into account the individual circumstances of an individual. And number three, you're required to take into account the financial condition of a defendant, which I will talk about here. Lastly, you're required to take into account an empirically developed risk assessment, which my office has provided. So let's get started. First of all, Judge, I would respectfully submit, recognizing that you were the person that set the bond on the warrant, that it is absolutely absurd that I am sitting here from a position having to argue down from a $500,000 cash or property surety bond. That bond is inherently unfair. It violates the United States Constitution, it violates the Colorado Constitution, and it violates the legislative guidance as set forth in 16-4-102. Additionally, this jurisdiction wants to seem to have its cake and eat it too when it comes to you judges. First and foremost, the statute says you shouldn't have a bond schedule. When I complain about a bond schedule, the judges say, well, we want to have a bond schedule so that we can release some people just in case we need to before their advisement, so it benefits your clients. Well, the bond schedule that you have signed, Judge, for a Class 2 felony says that bond should be set at $50,000. So without taking into account individual circumstances, without taking into account anything, you basically set a bond 10 times what the bond schedule is in this jurisdiction. It's absolutely absurd. It's not fair. It's not reasonable. And it's absurd that I have to be talking down from that rather than starting at a presumption in favor of non-monetary conditions of release as required under 16-4-103. Second of all, this same bond schedule that you have signed says that you don't take into account and stack individual counts. To the best of my knowledge, the warrant for the rest of the defendant, which you signed on May 21st, only establishes one count, and that's one count against what's presumed to be a child who's borderline incompetent by operation of law with the age of 14 years old. It doesn't go into the other allegation, and certainly there's not a request for two allegations or two charges of criminal attempted first-degree murder. So we're talking about one allegation of attempted first-degree murder. I would respectfully submit to the court that the likelihood of conviction based on what a 14-year-old says that a person pulled out a gun and shot at him is unlikely. And I think you can gather that from the affidavit when the law enforcement officer himself on the last page in the last paragraph says, given this information as well as the consistent accounts from Fred, Katrina, and Micah, there are grounds for a charge of menacing under Colorado revised statutes. So the officer initially doesn't even ask for attempted murder. He asks for a menacing. I would respectfully submit that if the allegations are true, which I don't believe they are, and Ms. Schlecht is this close in range, as the 14-year-old child says, he's near the road, she pulls over on the road, and the allegation is that she shoots at him, that if she wanted to kill him, she would have. So I would respectfully submit that this is more of a situation of menacing.
That's his argument? Judge, it's not attempted murder because if she wanted him dead, she would have shot him dead. That's your argument, sir? She shot at a 14-year-old boy or girl. 14-year-old. Respectfully. But this judge is keeping his cool. He's going to think about the law and apply the law.
If it's proven to be true. There's no idea that the kid was hurt. There's no idea that the kid suffered serious bodily injury. There's no, in any way, allegation the kid went to the hospital. I mean, I don't know how anyone...
You don't think that's traumatic to a 14-year-old? Some crazy redheaded woman shooting you? You don't think that's traumatic?
You know, with a straight face can say that this was a substantial step in injuring anybody. Other than possibly what the original law enforcement officer indicated, which is a menacing. Now, taking into account the individual circumstances of Ms. Selecta, she has no prior felony convictions. She has ownership of a dangerous dog. That's the best that Ms. Gonzalez can do, an M2 conviction. She has, to the best of my knowledge, never failed to appear. When I represented Ms. Selecta back in county court in Crowley County.
For her other crimes. You know, when she was committing all these other crimes, she always showed up for court, Judge.
She was very involved in her cases to the point where she called me on a regular basis, wanted to meet with me on a regular basis. She scores in the lowest risk category possible, at risk category 6, which puts her in a success rate of 97% for new arrests, a success rate of 91% for failures to appear, and a combined success rate of 89%. She also has ties to the community in that she's lived in the area for 8 years. She basically lives with friends in the area. She can walk to court, and there's no indication, at least that I can tell, that she's failed to appear to court recently. She's currently on SSI disability. SSI, and receives $1,200 a month. And so if you look at her financial condition, it begs for a personal recognizance bond, if you're going to follow the law. If you look at her individual circumstances, it begs for a personal recognizance bond, because if you're going to follow the law, she has no history of any significant...
If you're going to follow the law, attempted murders, that does not give PR bonds. You don't get PR bond on attempted murder, sir.
Conviction. If you're going to follow the law and give her a presumption in favor of release with the least restrictive conditions, you can fashion any condition that would address any safety concerns. If you're going to follow the law and take into account an empirically developed risk assessment, which my office has presented to you, then she scores in risk category 1 and she should get a PR bond. If you're going to follow the United States Constitution, which guarantees her a presumption of innocence and a right to a reasonable non-oppressive bail, then you should have never set a $500,000 bond on the warrant, and you should go no more than $50,000, which she was not going to post anyways. Lastly, if you're going to follow the Colorado Constitution or CRS 18-1402 or CRS 16-4101, then you should give her a PR bond as well, because all of the circumstances, except for the allegations of a borderline incompetent witness in this case, scream for a personal recognizance bond. So again, I think it's inherently unfair to this lady that we are starting at a $500,000 bond. We should be starting at a PR bond and letting Ms. Gonzalez make the argument why it should be up to $50,000, which is what the bond schedules that you signed, puts us at. When you sign a bond schedule, that means you're inherently believe that it's reasonable. And the bond schedule for an F2 is $50,000. So what makes this one so much more egregious? What makes this one 10 times more? No serious bodily injury, borderline incompetent client, no additional allegations other than one alleged count. I just don't understand how we get where we are. I understand you're frustrated with the argument I make, Judge. I understand it was probably not worth making because Ms. Schlechter is not going to probably be able to post a $10,000 bond, much less a $500,000 bond. But if you're going to follow the law and honor the law that you ask defendants to honor when they come in front of you, then you should follow the law. You should follow the Constitution. And both of those, all three of those, the United States Constitution, the Colorado Constitution, and the Colorado Revised Statute say that she should be given a PR bond in this case. Thank you.
All right. Thank you, counsel. I appreciate your argument. I appreciate the argument of the people in this case. The court did review the affidavit of probable cause, which was for attempted first-degree murder. That is that the defendant, on or about the date and place charged, intentionally, attempted to cause the death of another person, in this case through the discharge of a firearm. The discharge of a firearm that was identified by several witnesses in color and in caliber. The discharge of a firearm at a 14-year-old, at least as alleged by the 14-year-old, after she had previously told others she was going to shoot the 14-year-old. To include, she told the 14-year-old that she was going to shoot the 14-year-old. If she had accomplished the first-degree murder that she indicated she was going to accomplish, that would be a $1 million bond pursuant to the bond schedule, which the court doesn't always follow and doesn't necessarily follow in this case or any other case. If she just pulled out the gun and shot him sort of on the spur of the moment, that would be a second-degree murder, which would be a $500,000 bond. So an attempted first-degree murder in this court's rubric, under those facts and under those circumstances, when one announces the intent beforehand, specifically to that individual, without first taking into account Ms. Selecta's individual circumstances, which the court didn't know when setting the bond, certainly makes a $500,000 bond reasonable in this court's estimation, given that announcement of premeditation and identification of the specific firearm and caliber of the firearm by other individuals. So that was the initial setting of the bond. Now, having taken into account the CPAT-R, the fact that this particular individual is on SSI disability, the individual circumstances of this person, the individual circumstances of this case, which this court finds egregious, it may be, counsel, and certainly it's true now, that Ms. Selecta is entitled to every presumption of innocence. Nevertheless, this court did find probable cause for...
Oh my gosh, Bobby, that would have been so funny if he would have raised the bond. That would have been... But no, the judge isn't petty. He's a judge.
Attempted first-degree murder. It may be that the case is not ultimately proven. Nevertheless, the court finds that Ms. Selecta would be a danger to the community. She does have 9 prior failures to appear, although, as pointed out, none of those terribly recently. So in balancing all those factors, the court will reduce bond to the amount of $150,000 cash or corporate surety. Clearly, a PR bond is not appropriate. Clearly, a low bond is not appropriate given the alleged behavior, the announced premeditation, the very identification by multiple parties of this individual, and the color and caliber of the firearm. Given all that, the court finds $150,000 cash or corporate surety bond to be reasonable. Ma'am, if you do post that bond, you'll have to waive extradition. I'll also issue a protection order in this case. The court will order Ms. Selecta that you have no contact of any kind with the alleged victims or the alleged parties in this case and witnesses to this case, Micah Arnston, and Fred Hunsaker. I'll also order that you shall not harass, molest, intimidate, retaliate against, or tamper with any victim or witness to the crime. It'll be a condition of your bond and a condition of the protection order that you not possess any firearm or firearm ammunition or any weapons during the pendency of this case. Ma'am, do you understand the terms and conditions of your protection order? I'm sorry, I didn't hear you, ma'am. You were muted.
Yes.
All right, thank you. It's important that you do, because if you violate any of the terms and conditions of the protection order, you could be charged with the crime of violation of a protection order. That's a misdemeanor, punishable by up to 364 days in jail or a fine of $1,000 or both. In addition, you could be found to be in contempt of court. Contempt of court is separately punishable by jail time or a fine or both. Finally, if you engage in witness intimidation or retaliation against a witness or victim in any case, then you could be charged with state felony charges, which are very serious indeed. I do find that this is a victim case, that at least as alleged, this is a violent offense in a victim case. Your next court appearance, ma'am, will be on June the 9th at 10 a.m. in front of Judge Vigil. That'll be in the Crowley District Court. Anything further in this matter, Ms. Gonzalez?
Nothing additional for me, Your Honor. Thank you.
Mr. Torres?
Judge, I'm not trying to argue with you. I'm trying to preserve an appellate record. Ms. Schlechter has the right to appeal your bond decision. I would just respectfully ask where you are getting the $1 million bond for a felony and the $500,000 bond for a Class 2 felony. The last bond schedule I have is Administrative Order 22-04A, which I intend to file as a part of this record.
He said 22-04A. So that's approximately the year that bond schedule came out.
But may I ask where the court is getting the numbers of $1 million for a Class 1 felony or $500,000 for a Class 2 felony?
Give me just a moment, counsel. That is the 16th Judicial District, Second Amended Bond Guideline 2024-01B.
24.
2401B.
That's 2 years more recent, sir.
Yes, sir.
Is there a date
August 5th, 2025, sir.
Yes, sir. Just a couple months ago, sir.
You're on mute, sir. You're muted.
Thank you, Judge. Ms. Schlechter, I assume you're not going to be able to post that bond. Is that a fair statement? Yes or no?
Ms. Selecta?
No.
Okay. Ms. Schlechter, I'm going to open up a file on you. I assume you want continued representation from the Office of the State Public Defender?
Yeah.
Okay. The attorney that's going to be assigned to your case is an attorney by the name of Rusty Zane. I would encourage you, I will personally contact him and let him know
Sir, you don't have conversations like this on the record.
about your case. I would encourage you not to talk about your case over the phone, okay?
Okay.
Okay. I have nothing further, Judge. Thank you.
All right. Thank you. We'll close the record then in this matter. Thank you all for your appearances and your very fine arguments today.
All right, let's listen to more lawyers arguing.
Call 25M2994, people of the state of Colorado versus Nicole Bradley. Mitchell Baser for the people.
Ben Hartford for Nicole Bradley, who sits to my left.
All right. Good afternoon, Mr. Hartford. Good afternoon, Ms. Bradley. Ms. Bradley, how are you today?
Nervous?
Understandable. All right, we are here for the second part of the motions hearing. There is a dispute raised by the prosecution as to the specificity of the pleading with regard to express consent and what is being challenged. Mr. Baser, the objection kind of came in the response. Any further record?
Nothing further. I do want to lawfully fry at this point based on I have the paperwork. I know the court doesn't want the actual thing. I'm just passing that on the record to defense counsel. Would like that to be completed by the end of the day. Just based on what's been filed, my confusion here is we've already litigated all the issues that were raised except for Colorado Express consent. So the people did respond with case law, as well as submitting an exhibit to the court for review. We're ready to proceed on that issue if that's really the only outstanding left. It appears that there's a witness for the defense, but I just find that this is kind of something that's really outside the scope of, or sorry, not outside the scope, but just trying to relitigate issues that the court already ruled on. And I want to make sure that we're not getting into doing that.
All right, Mr. Harford.
Yes, Your Honor. And Your Honor, first of all, I think that, saying that we've already litigated this issue when we had a witness who was unavailable is a bit disingenuous. I think that having arguments heard as to Officer Garner was fine and proper, but I don't think that all of the evidence was in. And I did not concede that Officer Rytel, who was on scene and who was present for the entirety of the stop, wouldn't have necessary material information. And the court itself, as I pointed out in my motion, and said that there was information that it wished it would have had. And that information is certainly potentially available from Officer Rytel. And so I think that the issue as to Officer Garner, the court heard Officer Garner's testimony. The court heard what he had to say, but that was not all there was to be heard. We have another sight sound witness in Officer Rytel. I think that he has to be subject to cross-examination, and that cross-examination very well could be determinative upon the court's ultimate rulings in this case. And I think that to deny my client her due process rights, as the prosecution would be requesting, would be just that. It would be denying her rights to a fair proceeding. And ultimately, it's their burden to prove their case. And by denying us the ability to cross-examine that witness as to what his dealings were on the stop, on the seizure, and basically his interactions with my client would be a due process violation. And I think that rushing to judgment is exactly what the prosecution is requesting this court do. And I think that the court should take a measured, reasonable approach and let the defense have its cross-examination of Officer Rytel as to the issues that have been covered in the motion. And so this isn't a surprise. The prosecution requested that we provide them an idea of what we were going to be going into. I laid it out for them. Not that there was necessarily a statutory or legal requirement for the defense to do so, but the court had requested that, or the prosecution had requested, and the court had ordered defense to provide that. So we did. And so I think that prosecution is certainly capable of moving forward on this matter today, capable of putting their witness up, subjecting him to cross-examination. And I think that I should be able to go into the issues that I have outlined in my motion, and I think that would be a violation of my client's due process to disallow that at this time, Your Honor.
All right, Mr. Harford, we went to an original motions hearing on this case back in November on the 17th. At that time, had you subpoenaed Officer Rytel?
No, Your Honor. My request was and still is that the people had the burden to show
that both officers were, I believe both officers would be present because Officer Rytel was the one who provided the express consent and was present throughout the entirety of the interaction. So it was my belief that they would be calling him based on those requirements and based on what I had requested in my motion. And so I don't think that that request is proper to put the onus on the defense to subpoena an officer in a motions hearing where constitutional issues are at issue for the defense.
All right. So a couple of things. You never raised express consent or challenged to express consent in your original motion. The reason the court continued this for a second hearing was because of that. You raised it in your argument. I don't allow motions by ambush in that way. So I hate that term, but I will say by surprise. So the prosecution said, well, we didn't know this was an issue. We don't have that officer. So I said, all right, we'll have a secondary motions hearing for that issue. But you are correct. The prosecution has the burden to essentially produce evidence to meet certain standards depending on what's challenged. But if something isn't challenged, the court doesn't find it reasonable to hold the prosecution to their burden of production and proof if they're not on notice.
Sure.
I think that's a fairness issue.
Sure.
So
understood.
The fact that Officer Rytel could provide additional contextual evidence or testimony to all of the motions is not really my concern right now. And the reason for that is you had the opportunity on behalf of Ms. Bradley to subpoena him if you thought he was necessary for that purpose. You have no obligation to call witnesses or present evidence. It's all a strategic decision or call by you. But the court has no intention when it set the secondary hearing to reopen defense 8, I think it is, for full-blown testimony that could have been provided on the day of the last hearing, November 17th. Because, and this is unfortunately just a fact we have to deal with, this incentivizes defense counsel to go to hearing. If defense counsel loses or the defendant loses the hearing, to then say, well, the prosecution didn't have every available witness or every possible witness to provide evidence. It's a due process violation for my client not to be able to present that. We would have every single witness in every single case subpoenaed for every single motions hearing. We'd set one motions hearing a day and likely wouldn't finish it. That's just not how the process works. If you believe a witness has evidence, regardless of whether the prosecution is going to call them, if you want them, you have to subpoena them and bring them to court. That's Ms. Bradley's right, as it is to any defendant. I don't find that it's a due process violation to not allow Officer Rytel, I believe is his name, to testify and reopen litigation of all already decided issues. I am prepared to allow the prosecution to put him on to talk about the express consent, which hasn't been actively litigated. The only mention of express consent in the most recent motion is that it may be addressed. It's not a lot of specificity, but frankly, the general issue everybody was on notice about, and that's why we're here today.
And Your Honor, but this is the issue, I guess, is defense was under the impression that Officer Rytel would be present at the hearing. And I guess the defense, I should have requested that we set the matter over for Officer Rytel to be here. But the issue that the court brings up is that it's not fair as it would ambush the prosecution. But the defense has filed a motion outlining the exact fact as to what is at issue here and why Officer Rytel's testimony is necessary and material. And so ultimately, I guess denying my client the ability to fully and fairly cross-examine a witness is the exact definition of due process. Officer Reitel, as the court rightly pointed out in its findings, Officer Reitel was present. There's questions about Officer Garner's credibility, and there are questions about the stop and seizure that the court specifically brought up in its findings, specifically where the cars were located, which Officer Garner could not testify to, specifically what was said and how the interaction between Miss Bradley and Officer Reitel originated, which he could testify to, and ultimately to deny that and to deny the defense the ability to cross-examine and have that information. It's just inconceivable to the defense that is absolutely a fairness issue, and he's here. And so this isn't we're doing this for the betterment of the system. This is Miss Bradley's rights, and the court saying, well, every court and every defense. I mean, frankly, many defense counsel file motions, for various reasons that don't go. There are a plenitude of motions that are filed that never go. And to say that this is for judicial economy, when we have the witness here, when the witness is available, and when the court itself said there was information that it wished it would have had, is anathema to the fair administration of justice. And I would just make a record that to not allow me to go in and cross-examine Officer Reitel on these issues, when it was my belief and my understanding that he would be here at the original hearing, and was my intention to cross-examine him at that juncture, and he just wasn't available, and we have reset this many, many, many times, I think is and would be a miscarriage of justice for my client and her rights.
Mr. Harford, I understand your position. The problem is the court has already ruled on this omnibus motion to suppress. The only portion of the argument I didn't rule on was the express consent, because express consent was never raised. Prosecution, whether it was a risk or otherwise, opted to call only Officer Garner. The court, as it does often in its rulings, makes comments such as the outcome of this case could have been different if the court heard certain things. I do that because I'm a county court judge, and I often deal with young attorneys on both sides. That's my way of signaling to the attorneys that next time they might want to consider presenting that evidence to contextualize the encounter and possibly receive a different ruling. That's not my way of saying file another motion, have an entire new motions hearing with a new witness. It's an educational tick I have on the bench. The court is prepared to hear the express consent issue, which was never raised in writing before it was raised on April 27th in an additional omnibus motion where Ms. Bradley indicated her intent to reopen all of the evidence and argue all of the issues again. That's the court's position. That's the order of the court. The record has been made with regard to Ms. Bradley's objection to the court's proposed procedure. We're ready to go forward and call Officer Reitel.
Your Honor, we're going to call Officer Garner. He's available. He, Lake Foundation, was present during the Colorado Express consent. It's a motions hearing, and fellow officer would apply.
Court's recollection, and I refreshed by reading through the notes in this case, is that Officer Garner said he didn't know about express consent.
That is what
when he testified on November 17th. So what's changed?
Well, and at that time, I didn't prepare him for the Colorado Express consent, but since he's gone back, and this is actually his body-worn camera, he was sitting there, and as soon as, and I'd allow him to testify to this, but as soon as Reitel was done reading it, he got up and administered the breath test, so he was paying attention while it was being read.
Your Honor, I would absolutely object to this. I think this isn't proper. We've set this over for Officer Reitel now 2 separate times. I was expecting Officer Reitel. He's the officer who provided the express consent. He is the one who has relevance. Officer Garner already testified on the record in open court that he has no recollection of it. And, him going back through body-worn cameras does not necessarily refresh his recollection. This is exactly why we're here. We're here for Officer Rytel. I don't understand why the prosecution isn't willing to call Officer Rytel.
You can absolutely go to your body-worn camera and refresh your recollection, sir. You just can.
This time, is there a disciplinary issue, or is he not with the department? Is there something that some reason he's not available to testify here today?
Maybe he's watching The Bachelorette. You ever think about that?
Your Honor, Mr. Baser, I think the expectation was the officer who conducted the express consent advisement would be here. My other question is, from my review of what you submitted, I don't know whether there was a prior express consent advisement at the time Ms. Bradley was taken into custody.
Yes, Your
It
Honor.
seemed like it kind of picked up as a secondary advisement to me.
No, it was being read to Ms. Bradley. She started crying. They provided some tissues to her, wiped her face, and then said, I'm going to read it and reread it from the beginning. And she kind of already knew where he was in the middle of the express consent. I think she was just emotional given the circumstances.
So what was submitted is not the full express consent advisement.
That's the full, read from the form and then signed by Ms. Bradley. I can quickly ask to recess, cut the entire 10 minutes and play it for the record. But I do have Officer Garner here ready and prepared to lay foundation, introduce the exhibit. And in my written motion response, I transcribed the entire statement. It was read verbatim, word for word from the express consent form produced by Aurora Police Department.
And there was no on-scene express consent advisement.
No, not at the place of the incident of the traffic stop.
Yeah, I would object. Obviously, where is Officer Rytel? I still haven't had an answer to the question as why he's not here.
I have no idea.
So
I thought he was in the hallway.
So I'm going to say this again. I say it all the time. You don't get to pick who he calls. I understand you guys thought that other officer was going to be here, but if you need that officer, you should have summoned him. You are a lawyer. You are putting on a defense. You can't tell the prosecution what to do. Yeah, the prosecution changed his mind, picked a different witness. But I don't think there's anything wrong with that. If you needed that guy here, you need to have him here.
With the prosecution as to why he's not present.
Mr. Baser, why Officer Garner?
He's unavailable at this time. I have Officer Garner here.
Why is he unavailable, Your Honor? That's what I want to know.
All right. I'm going to pass the matter. I'm going to let the parties discuss if they want to discuss. I'm going to take the case that's ready to go forward,
I don't think I've ever played
and then I'll recall
tetherball.
the matter. Versus Nicole Bradley. Parties are present. Ms. Bradley's present. Counsel. All right. We're ready to proceed.
I agree, Kelly, if you say they can't proceed without that officer. I agree with that. But I do not agree. I do not agree with the defense telling the prosecution who they need to call. You just can't do that. If he wanted that officer, he should have that officer. Now, the judge thought this other officer was going to be here. If the judge wants to say, well, then we're not going forward, because you said that's one thing. But the defense telling the prosecution who to call, no.
Mr. Hartford.
Your Honor, I had specifically requested of the prosecution as to the whereabouts of Officer Rytel. The prosecution just informed me, wouldn't inform me as to where his whereabouts initially. I had to do my own investigation to learn and ascertain that Officer Rytel is no longer with the Aurora Police Department. I do not know if there are any emergent disciplinary issues that are in the pipelines. I don't know that yet, and I haven't had. I've learned this minutes ago.
Maybe he was fired because he's a corrupt cop, and all of his testimony was lies anyway.
Believe that The prosecution should have informed the court as well as counsel that Officer Reitel would not be available, or that they were not going to be bringing in Officer Reitel prior to the actual hearing. I think that I think that there are specifically ethical tenets that if a witness is unavailable for a hearing or for a jury trial, that the prosecution is under and has a duty to let the defense know that that individual would not be present. And Mr. Bashir has failed to do that. In addition to that, we had specifically requested that Officer Reitel be present. The court has already previously heard from Officer Garner and that he had no specific recollection of express consent or the admonition that was given. And therefore, I would ask at this time, since Officer Reitel is an unavailable witness, the prosecution has known about this hearing for months, that our motion as to express consent is granted and that all evidence as a result of that express consent be suppressed at this time.
Mr. Bazer.
Your Honor, there's been no case law or rule cited to grant such a motion. First, the people are ready to proceed arguing Colorado express consent. I asked for counsel to provide any scintilla of legal case law supporting why it should be suppressed here. Just because Officer Reitel is unavailable does not mean that we're not ready to proceed. We have the ability to call an officer who has personal knowledge that was there. The only reason why Officer Garner was unable to testify to that fact was we were not put on notice. I was not able to actually give him body-worn camera of that time. He watched all the body-worn camera of the traffic stop. The main issue that defense wants to argue today is reasonable suspicion and PC, not actually the Colorado express consent. It's still a concern for me that defense is still trying to argue that now, just reaching with Officer Reitel's unavailability for reasons to grant the motion. Additionally, Officer Reitel was not admonished, or there's no Rule 16 or Brady letters or anything regarding his service in Aurora. I'm making a record now that he transferred to another police department in Illinois to be with family. He's ready and available for jury trial for judicial economy and to Miss Bradley's expense if she were convicted. If we flew out Officer Reitel just for a 3-minute exhibit to be introduced that another officer could do, I actually tried to save her potential expenses if convicted, as well as the people and the judicial economy in general as a whole. We are ready to call Officer Reitel if necessary for jury trial, but because it's a motions hearing, the fellow officer rule does apply and the rules of evidence are relaxed, and Officer Garner can lay foundation, as the court has already observed the 2 minutes submitted, that it was read verbatim from a sheet of paper that says that you're advised of these rights. Do you consent to a chemical test of your choosing? Ms. Bradley said, I don't care. And Officer Reitel responded, I can't choose for you. And so she said, breath. Officer Garner is the actual officer that administered the I-9000. So the people are ready to proceed. This is a very straightforward issue. I can even rest on my motion after Officer Garner lays foundation, but the court should deny defense's request. There's just no basis for that.
And just to respond, Your Honor, I've learned about this literally 10 minutes ago, so I haven't been able to actually do any research. If prosecution had let me know that Officer Reitel was not going to be present and would not be available, I could have fully briefed the matter and provided case law as well as research to the court as to why this would be impermissible. Just off the top of my head, I don't believe the fellow officer rule applies when an officer would not have been in earshot. Having him look at body-worn camera and specifically refresh his recollection through a medium that he wasn't present for, I think.
Sir, it's his body-worn camera. He was in earshot. He was right there. He's watching his own body-worn camera.
I think defeats the entire purpose of the fellow officer rule. And specifically, when asked asked originally about whether he was present, he did not believe. His response was, "I don't have any specific recollection of being present or administering the express consent admonition." So, under those circumstances, I would ask this court to allow for the defense to take this matter up and to brief this matter fully, in that the court specifically says it does not like to have the parties trial by ambush. This is the exact definition of trial by ambush. Not telling me until the middle of the hearing or right before the hearing as to this issue is the exact thing that this court says it does not like the parties to do to each other, and that has been done. So I would ask for that leave, Your Honor.
All right.
Ask for sanctions too. Ask for sanctions.
Here's the issue from the court's perspective. I agree to an extent that an officer who was not present could not authenticate another officer's body-worn camera because they just wouldn't have any personal knowledge under 602 or under 902 or any of the other rules of hearsay. However, it's been represented by the prosecution today that what the prosecution intends to introduce is Deputy Garner's body-worn camera. Is that not correct, Mr. Baser?
It is, and it's in the notice of submission of media.
If it's Officer Garner's body-worn camera, he necessarily had to be present unless the testimony is, I removed my body-worn camera, set it up on the edge of the table, and then walked away. Prosecution, as I noted earlier, takes a risk anytime it calls less than all of the officers who were present. So the prosecution is going to have its opportunity to admit its evidence today. If it can, then the court will make the ruling based on the evidence it's submitted. If the prosecution can't get its body-worn camera exhibit in, then the court will rule based on the evidence. Not going to give advisory opinion on what the evidence is going to be and what the ruling is going to be. But the prosecution understands the challenges to express consent. It's their obligation to produce evidence and meet the burden that the express consent advisement was correctly given, and that the prosecution met its obligations to Ms. Bradley, as the statute is very clear and the case law is clear that there are competing obligations for both sides, law enforcement and a defendant. So it's going to come down to whether the prosecution can admit the evidence they brought today. If they can't, then I'll rule. And if they can, then I'll also rule.
Your Honor, at this point, I am not prepared to proceed, just because I've been given this information literally 1 minute before the hearing started. That's, in my opinion, unprofessional, the prosecution, and puts the defense at a distinct disadvantage. I was not looking at the issue, body-worns, or anything through that lens, and because of that, I am not prepared to proceed, and I would ask for a short continuance.
Last time we set this over, it took 6 months.
I understand that, Your Honor, and if I'd had any notice, literally any notice, then this would not have been an issue. So I would ask that this be charged to the defense, or excuse me, to the prosecution, since they.
Donald, hold your hand over. Hold your mouse over your comment. So some of the comments, YouTube is translating to something completely different. That's why every time Ginny comes in here, everybody says porcelain.
They knew of this and have known of this for a period of time and chose not to share this with the prosecution and gamesmanship over professionalism before this court. So I don't think that the defense should be put at a disadvantage because the prosecution chose to neglect to tell the defense that this is what the status of the case was, and this is what the status of the witness is. That is the definition of trial by ambush, and that is specifically would put me at a distinct and resolute disadvantage since I have not prepared that issue, and I have not had an opportunity to look at the body cams with any specificity as to Officer Garner.
Mr. Baser?
Yeah.
Body cams are definitely in discovery. They're definitely there. So he can't say he didn't know that they were going to look at body cams during this motions hearing. That's stupid.
Your Honor, on May 3rd, 2026, I filed a notice of submission to media. Clearly indicates the 1 minute of the exhibit regarding Colorado Express consent. It also lists Officer Jamie Garner as the officer's body-worn camera that's being submitted to the court. That's notice to the defense as well as a full response, citing case law, citing the facts, reciting the facts, excuse me, of that exhibit, and asking the court to make a determination if the exhibit is introduced based on the law and the facts. It's a bit concerning. Again, Ms. Bradley's attorney is claiming that I'm unprofessional. There's a potential investigation.
There's no need to respond.
Thank you.
If the parties want to take up each other's professionalism or behavior, you can do so in another venue. I'm not going to sit here and have this back and forth.
I appreciate that, Your Honor.
I want to make sure that on the express consent issue, Ms. Bradley is able to have her defense put forward. Speedy trial is set 9/21/26 based on the waiver of speedy back in late March. The court has exceptionally limited availability for motions hearings. Mr. Harvard, you don't regularly practice in here, so I don't anticipate you know, but we are 8 to 10 trials deep at almost every setting, which means we're setting 4+ motions hearings every day, Monday and Tuesday of every week. The soonest the court could offer a hearing on this issue is trying to save myself time, June 22nd at 2:30. I don't like having to continue this, but I want to do it one time and one time only.
Hello.
I have a
Your Honor, I would just object. I mean, we're ready to go. At least it should be told on the defense, if anything, based on the docket. We're ready. The defense has been on notice. I've made it clear in our communications that there are no issues with Colorado Express consent, and I have not seen anything that indicates that there really is a challenge. I think the actual basis of this motions hearing is to relitigate all the issues, and I would just request the court, if we are to truly relitigate Colorado Express consent, to actually have particularized facts that can actually articulate what's the issue here, because the people are ready to proceed on this. And my filing over a week ago, at least gave the defense notice of what's going to be challenged and what's going to be addressed. I just find that this should not happen based on what's going on. Thank you, Your Honor.
All right. The record is made.
Where in the motion is it stated that Officer Reichel was unavailable and not going to be here? It doesn't say that anywhere.
Mr. Harvard, I'm going to grant the request to continue the matter.
Thank you, Your Honor.
What is your and Miss Bradley's availability June 22nd at 2:30?
I am in a trial that entire week. That could change. It's a civil trial, and there is a mediation at the I believe end of May, towards the end of May. See here. That we're working out, but as of right now, the 22nd is unavailable for me. Is there a day of the week that the court has?
Monday and Tuesday afternoons.
I would have the 29th or 30th. I could be available for either of those 2 days of June.
That makes one of us.
I get why the judge granted it. I don't like it though. I mean, he has to give her her best shot, but he shouldn't have. He had plenty of notice. He knew what today was about. Just because it's a different officer. No, the judge is just trying to find a date and time. He's just looking. That's why it's so quiet.
May 19th.
They're very early. It was most likely Zach. Most likely. He has a channel called Law Nerds Unite. But it's good to see you here tonight. Thank you for coming in.
Next Tuesday at 2:30,
That would be, what's the date? I'm sorry.
May 19th.
I'm set here in front of Judge Williford on some motions at 3 p.m. At 1:30?
2:30.
I mean, maybe if is it possible we could do it at 1:30, or is there a docket that?
There's a docket.
I don't know if the court has the 18th, May 18th.
I don't believe we do.
I could also do the 25th, and I can rearrange the 26th if the court has any availability in either of those 2 days.
I'm about to eat a huge roast beef
The
sandwich.
25th is a court holiday.
Just a couple more minutes. But that judge was wishing he would have said, all right, let's just go forward.
July 20th at 2:30.
That I can do.
Prosecutor just left.
Mr. Baser? 20th? Ms. Bradley, does that work for you?
Yes, it does.
Mr. Baser, does that work for you?
Well, no, Your Honor.
And Your Honor, I don't want to take up an argument today, but since the court has indicated that, from a procedural standpoint, I know that the case, we had bifurcated the motions hearing, and I wasn't going to file a motion to reconsider until the matter was concluded. But since the court has indicated that the initial issues as to not express consent, as to the stop, as well as the administration of STs has been decided, I would request leave from the court to, within the next 14 days, file a motion for reconsideration. And specifically, and I have this.
He was right. He just wants to relitigate everything. That's why we're here. That's what this motion hearing is all about. He just wants to relitigate everything the judge already ruled on. See, you should have listened to the prosecutor. Anyway, love the replay crew. Love you all.
Approach, Your Honor.
I'm not sure what it is. Have you shown it to the prosecution?
I'm giving a copy to
All right. Go ahead. Thank you.
Prosecution should yell, trial by ambush. He didn't tell me anything about this.
Statutory authority. And specifically, I would, and I'll certainly, I can obviously file a written motion explaining what the
It burns my mouth.
reasoning is, but I can certainly provide this to the court. Under 16.3.310, I do not believe that Officer Gardner complied with the statutory requirement to tell Ms. Bradley specifically that she had the right to refuse, as well as, let's see here, under B1 and 2, a peace officer may conduct consensual search only after articulating the following factors to and subsequently receiving consent from the person subject to search or the person with apparent or actual authority to provide permission for search to search a vehicle or effects. The factors are the person being asked to voluntarily consent to search, and the person has the right to refuse a search. I believe that the court is already in receipt of the body-worn camera. I do believe also that Officer Garner failed to, the court did in its findings establish that no probable cause existed when she did and was requested to do SFSTs. And therefore, under 16.3.310, it is the defense's position that Officer Garner violated this requirement, the statutory requirement, to inform her that she had the right to refuse and that this was a consensual request. And I don't believe he did so. And I can certainly expand upon that in written form, obviously.
All right. As I say to everyone, the court will consider any motions that are filed into the case.
Thank you.
When they're filed into the case and rule accordingly.
Understood.
Ms. Bradley, would you like a written reminder of the July 20th date?
No, sir.
Get the text messages?
I do.
All right. And Mr. Baser, did you confirm that you were available for that date?
No, not yet. I'm just.
Oh, and just for the record, Your Honor, counsel provided me with plea paperwork, and I did and have informed my client, advised my client, and as of this moment, we are declining to exercise that plea option.
All right, Mr. Hartford, my position is it's not appropriate for this court to know what the plea offer is because of long established principles in the state of Colorado that the court should not be involved in plea negotiations. Some courts allow a Loeffler-Frye record to be put on the record. What I require is if a offer has been made that the prosecution presents something to the defense that states the offer and allows the defendant to sign that they've been advised of the offer. And then the prosecution keeps that in their file in case there's ever a 35C for lack of advisement / that the defense counsel never shared the proposed plea agreement. That way I never see it, but the prosecution can then upload it into the appellate record. That way there's nobody who can say, well, you saw this plea.
They provided me the plea paperwork. I don't know that I was provided a separate waiver.
Okay.
But I'm
Mr.
sure
Baser, the plea paperwork doesn't help me. There's nowhere for Ms. Bradley to sign to acknowledge it.
I'll send.
I just need a sheet of paper with the offer and then Ms. Bradley to sign acknowledgement of receipt of the offer, and then she's been advised that it goes straight back to the DA. Don't upload it into the court file. That'll defeat the purpose.
Understood, Your Honor.
Okay. So, Mr. Baser, July 20th? That work? Okay, Ms. Bradley, we will see you back then, and we'll address.
And before the court rules, this is a tolling on the defense for asking continuance.
It's not a request to continue the trial. It's only a request to continue the motions hearing. The motions hearing will be set 2 months roughly in advance of the speedy trial deadline. So, not going to toll anything.
Okay. Thank you.
You're right.
All right.
You're right.
Thanks, folks. We'll see you back on July 20th.
I don't think this trial is ever
Thank you,
going to
Ms. Bradley.
happen, guys. What do you think?
Thank you, Officer Garner.
They're going to be
Thank you, Ms.
fighting over
Bradley's
stupid stuff.
mother?
That's my mother.
All right. Thank you for being here to support your daughter, ma'am. Thank you, Mr. Gilbertson.
And thank you guys for coming out today. I really, really appreciate it. It's great to see Replay Crew. And we had a couple of them in today. So that's really great. So some of you I'll see in about 6 hours. The rest of you I will see next time. Thank you so much for coming out. I appreciate it, guys. Have a great night. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.